guys, today we are going to discuss section 377 of the Indian Penal Code, which is the IPC, and talk about the rights of the LGBT community and what is the final legal stance. So most of us know that section 377 was decriminalized and was made unconstitutional in 2018 by the Supreme Court, but we do not know the background summary of it. Okay, how did it happen? I've even heard people saying that homosexuality is a disease which is new generation has spread. Okay, that is not so. If you look at some examples of Mahabharata as well, there were certain characters which depicted homosexuality. Okay, if you remember a character called Shikhandi, she was born as a woman but then identified herself as a man and then finally married a woman. Okay, if you look at the carvings of the Khajuraho temple, you will see that there are so many carvings in scriptures which clearly depict homosexuality. Okay, so that is not something which is new or novel to our generation. It's just that people are more aware about it, so people can openly talk about it, but still there is a lot of social stigma attached with it. Okay, so in 1861, the Britishers enforced the Indian Penal Code or the IPC in India. 377, section 377 stated that any carnal intercourse which is against the order of nature is a punishable offense. This is a very important phrase to understand, against the order of nature. Okay, it said it's a punishable offense if it's done with any man, woman, or an animal. And the punishment that was mentioned was 10 years to life imprisonment. Okay, now this is a huge punishment for something which is not even an offense. So, in the early 21st century, a lot of organizations and people started talking about it and started saying that this is unreasonable and basically infringing on their rights. So, in 2001, for the very first time, NAS Foundation, which is an organization which works for the welfare of the people and takes initiative in certain diseases like HIV, AIDS, and so on, it filed a petition in the Delhi High Court seeking decriminalization or basically making section 377 unconstitutional and allowing homosexuals to have sexual intercourse. The Delhi High Court rejected the petition, saying that they do not have the locus standi to file this petition. Now, what does this mean? It means that Delhi High Court said, since you are not an aggrieved party, none of you have been prosecuted under section 377, you cannot file this petition. They filed an appeal to the Supreme Court and Supreme Court directed the Delhi High Court to hear the issue on merit. Basically, an argument suniye and then decided. In 2011, the Delhi High Court finally delivered its decision and stated that section 377 is unconstitutional and is to be decriminalized. Now, what is the reasoning behind it? So, this Delhi High Court stated that Article 14 and 15 of the Constitution talk about right to equality and not to discriminate between sex. Okay, so that is what 14 and 15 says respectively. Whereas section 377 clearly violates Article 14 because it does not provide equality to people and it differentiates people between sex. And sex does not only mean gender or being a male or a female, it also means sexual orientation of a person. It also violates on Article 21 of the Constitution because right to live with dignity and right to privacy are two very important rights under right to life, which is mentioned in Article 21 of the Constitution, and section 377 violates on that as well. Now, this was called the NAS Foundation judgment, NAS Foundation versus NCT of Delhi in 2011 by the Delhi High Court. From this judgment, an appeal was done to the Supreme Court of India. Now, this judgment is called Suresh Kaushal versus NAS Foundation. Now, an appeal was made from the decision of the Delhi High Court to the Supreme Court of India. This decision is called Suresh Kaushal versus NAS Foundation. A two-judge bench of the Supreme Court decided and again made section 377 of the IPC as constitutional. Now, why did they do so? They did so because they stated that section 377 is gender neutral. उनका ये कहना था कि it does not discriminate between any gender. It is gender neutral and it can apply to any gender irrespectively. They also stated that there are less than 200 cases that are prosecuted under section 377. So it's not a matter of big worry. Okay. They also stated that just because the beliefs of the society have changed over a period of time, a section of a law cannot be made unconstitutional unless it violates any constitutional provision. So that is what was held in Suresh Kaushal versus NAS Foundation. Now, a review petition was preferred in 2014. A review petition was made to the Supreme Court, which was rejected outrightly. And in 2014, finally, the section 377 was again made constitutional. In 2014, another really important judgment came with respect to the rights of the transgender called the Nalsa versus Union of India. In this case, the Supreme Court realized and clearly held that Article 14, 15, 19 and 21, these are certain rights which are available to all the people in the country, does not apply to only men and women. It applies to everyone including transgenders. It stated that everybody has a right to live with dignity in this country, everybody has a right to not be discriminated on the basis of sex, and therefore it applies to everybody and all the genders in India. So it was a landmark judgment in India which for the very first time determined and brought forth the rights of the third gender in India. Okay, now in 2015, Shashi Tharoor, who is a senior Congress leader, he tabled a bill in the Lok Sabha decriminalizing section 377, where however it could not be passed by a majority and therefore it was brought down again and nothing could happen with respect to that bill. Now in 2017, a really significant judgment again came forth called the K.S. Pottasamy judgment, K.S. Pottasamy versus Union of India. This judgment is very important because it's a landmark judgment on right to privacy in India delivered by a bench of 9 Supreme Court judges. Yes, it was delivered by a bench of 9 Supreme Court judges and it stated that right to privacy is a very important aspect of Article 21. It went on to state that sexual orientation is a very important aspect of right to privacy and nobody can be denied to sexual orientation or their right to privacy. And even if a very small part of the population is willing to exercise its rights, they have all the right to do so, and no court or no law in the country has any power to take away that right from them. D.Y. Chandrachud, who was one of the judges in the 9-judge panel in the K.S. Pottasamy judgment, clearly stated that it is the duty of the Supreme Court to rectify its own error which it made in the 2013 judgment of Suresh Kaushal. However, they did not consider the constitutionality of section 377 in K.S. Pottasamy judgment because that was not something which was argued eventually. Now in 2018, just 1 year after the K.S. Pottasamy judgment, on 6th September 2018, finally the Supreme Court came up with a judgment in Navtej Singh Johar versus Union of India, which finally decriminalized section 377 and made it unconstitutional. The Supreme Court clearly stated that no discrimination can be made on the basis of sex in India, and sex also includes sexual orientation under Article 14 and 15 of the Constitution, which provides for right to equality to every person within the boundary of India. They also stated that Article 21 is a very important aspect of a person's right to life. Now, one good thing here was that Justice Chandrachud was also on the bench of this Navtej Singh Johar judgment. So you can see the opinions of 5 judges who were in the panel who unanimously made this section 377 unconstitutional. So finally in 2018, the homosexual community got what it deserved and legally found a way to preserve their rights. But still there was so much hue and cry about it because people felt that homosexuals are basically polluting the environment. That is what the social approach is. We consider it as a social stigma. It's still considered a taboo in our country, which is really problematic. Now, that was one of the criticism of the 2013 Suresh Kaushal judgment also, because in that judgment, while the proceedings were going on, a lot of medical professionals had filed various written submissions which stated that because people of the homosexual community or the LGBT community are discriminated so much that they fall into depression and are under a lot of stress because of this, because they cannot come out and express their feelings publicly. Even after such submission, the Supreme Court made homosexuality constitutional at that time in 2013, but in 2018 we got the desired result. And very recently, the Parliament in 2019 also passed an act called the Transgender Persons Protection of Rights Act 2019, which talks and preserves the rights of transgender community in India. So that's all about this session. I request you on behalf of 12 Minutes to CLAT to not consider anyone as unequal and don't consider homosexuality as a taboo and treat everyone equally. And if you like our sessions, please subscribe to our channel, press the bell icon so that you don't miss any updates from us. Keep writing to us, keep supporting us. Thank you.